Hey everyone, it's Lucas here, and welcome back to Immigration News with Lucas. Now listen carefully.
Breaking news from Washington that changes everything. Just minutes ago, Congress passed a groundbreaking immigration law that's about to reshape the entire system. If you're an immigrant in America, whether you're on a visa, have a green card, or are waiting for citizenship, what just happened on Capitol Hill will directly impact your future. This isn't speculation. This isn't a proposal. This is now federal law. And the changes are more dramatic than anything we've seen in decades. November 1 Stone, 2025. A date that millions of immigrants will remember. Because today, the rules change. The protections you thought you had? They might not exist anymore. The pathway you were counting on? It just got completely rewritten. And some of the changes take effect immediately. This is urgent. Whether you've been in the United States for decades or just arrived, whether you have a work visa, a student visa, or even permanent residency, this new law creates an entirely different playing field. And what's most shocking, even those who thought they were safe, who followed every rule, who built their lives here legally, are now facing unprecedented uncertainty. Stay with us as we break down exactly what Congress just passed, which immigrants will be affected, and most importantly, what you need to do right now to protect yourself and your family. The details are critical, and we're covering everything. What Congress just passed, the complete breakdown. Let's get straight into what happened. Earlier today, both chambers of Congress voted to approve what's being called the most comprehensive immigration reform package in over 30 years. And here's what makes this different from every other immigration debate we've seen. This bill actually passed. It's not stuck in committee. It's not being filibustered. It's not a campaign promise. This is now law. The legislation fundamentally restructures how the United States government handles immigration enforcement, visa processing, and the path to citizenship. But more than that, it redefines who gets to stay in America and under what conditions. This law introduces stricter behavioral standards, faster deportation procedures, and eliminates protections that millions of immigrants believed were permanent. The Unified Enforcement Framework. Here's the first major change, and it affects absolutely everyone who isn't a U.S. citizen. The new law establishes what's called a Unified Enforcement Framework. What does that mean in plain language? It means that every single non-citizen, regardless of their immigration status, now falls under the same enforcement umbrella. Before this law, the system treated different categories of immigrants very differently. Students on F-1 visas had certain protections. H-1B workers had others. Green card holders had even stronger safeguards. The enforcement approach varied depending on your status, how long you'd been here, and what category you fell into. That distinction is now gone. Under this unified framework, whether you're here on a temporary visa, a work permit, asylum status, or even as a lawful permanent resident with a green card, you're all subject to the same level of scrutiny and the same enforcement mechanisms. The federal government has essentially created one single category for all non-citizens, and that category comes with far less protection than many immigrants realized they had. This is monumental. For decades, green card holders operated under the understanding that short of committing a serious felony, their status was relatively secure. They could work, travel, build businesses, raise families. The green card was seen as the final step before citizenship, a status that provided stability and peace of mind. That security just evaporated. The criminal conduct provisions. Now we get to the part of this law that's causing the most alarm across immigrant communities nationwide. The criminal conduct provisions. This section of the legislation dramatically expands what types of behavior can result in deportation, inadmissibility, or denial of immigration benefits. The law specifically targets what it calls public safety offenses. And at the very top of that list sits one particular violation that's now treated with zero tolerance: driving under the influence. DUI offenses. Under the previous immigration framework, deportation proceedings were generally reserved for aggravated felonies, crimes of moral turpitude, or repeated criminal violations. A single DUI, especially a first-time offense, rarely triggered removal proceedings unless it involved serious injury or death. This new law changes that calculation entirely. A single DUI conviction, regardless of the circumstances, regardless of whether anyone was hurt, regardless of your blood alcohol level, and regardless of how your state classifies the offense, now serves as grounds for deportation at the federal level. But it goes even further. The law doesn't just target convictions. It also applies to admitted conduct. That means if you admit to driving under the influence, even without a formal conviction, immigration authorities can use that admission against you in removal proceedings. This could happen during a visa interview, a green card renewal, a citizenship application, or even a routine check-in with immigration officials. Why DUI became the focus? You might be wondering why Congress chose to focus so heavily on DUI offenses in an immigration reform bill. The lawmakers who championed this provision argue that drunk driving represents a clear threat to public safety. They point to statistics showing that thousands of Americans die each year in alcohol-related traffic accidents. Their position is that immigrants seeking to live in the United States must be held to the highest standards of conduct, and that includes zero tolerance for behavior that endangers others. Supporters of the law also argue that this isn't about punishment for a mistake. It's about selection. They say the United States has the sovereign right to choose who gets the privilege of living here, and that choice should favor those who demonstrate consistent respect for American laws and the safety of American communities. Critics, however, see this very differently. Immigration attorneys and advocacy organizations are calling these provisions draconian and disproportionate. They argue that DUI cases vary enormously in severity. A person who makes a poor decision to drive after 2 glasses of wine, gets pulled over at a checkpoint, and immediately cooperates with police is being treated the same as someone with multiple DUI convictions or someone who caused a serious accident. The law makes no distinction. Grounds for inadmissibility expansion. The legislation also significantly expands the grounds for inadmissibility to the United States. Inadmissibility is a legal term that means a person cannot enter the country or adjust their immigration status. Prior to this law, inadmissibility typically applied to individuals with serious criminal records, communicable diseases, or those who posed national security threats. Now, anyone with a DUI conviction or even an admission of DUI-related conduct is considered inadmissible. This has immediate and severe consequences. If you're outside the United States and trying to get a visa, a DUI on your record will likely result in automatic denial. If you're inside the United States trying to adjust your status from a temporary visa to a green card, that DUI becomes a permanent barrier. Even more concerning for many immigrants is how this affects travel. Green card holders who leave the United States for vacation, business, or family emergencies could find themselves unable to return. When they attempt to re-enter at a port of entry, Customs and Border Protection officers will now have the authority to deny entry based on a DUI conviction, even if that conviction happened years ago and even if the person has maintained a clean record since then. This provision essentially traps certain immigrants inside the United States. Leaving the country, even temporarily, becomes an enormous risk. And for those who need to travel for work or family obligations, this creates an impossible situation. Deportation procedures under the new law. The deportation mechanisms in this legislation represent another seismic shift. Under the new framework, any non-citizen convicted of a DUI offense can be immediately placed into removal proceedings. There's no waiting period. There's no case-by-case evaluation. The conviction itself serves as the trigger. Immigration and Customs Enforcement, ICE, will have expanded authority to detain individuals pending their removal hearings. The law also limits the types of relief available to immigrants fighting deportation. Previously, an immigration judge had discretion to consider factors like length of residence in the United States, family ties, employment history, and community contributions. Judges could grant cancellation of removal in cases where deportation would cause exceptional hardship. This discretion is now severely restricted when it comes to DUI-related cases. The law instructs immigration judges to prioritize public safety concerns above other considerations. In practical terms, this means that even if you've lived in America for 30 years, have U.S. citizen children, own a business, and have no other criminal record, a single DUI conviction can still result in a deportation order that's nearly impossible to fight. The appeals process has also been streamlined, which is a polite way of saying it's been made faster and harder to win. Immigrants will have less time to gather evidence, secure legal representation, and present their case. The government's stated goal is to reduce the immigration court backlog by processing cases more quickly. But immigrant advocates warn that speed comes at the cost of fairness. The good moral character requirement. For anyone on the path to U.S. citizenship, the good moral character requirement has always been a crucial hurdle. To become a naturalized citizen, applicants must demonstrate that they possess good moral character, typically over a period of 5 years before applying. This standard evaluates whether the person has been honest, law-abiding, and a positive member of society. Under previous interpretations, a single minor offense didn't necessarily disqualify someone from meeting this standard, especially if the incident occurred years ago and the person had since maintained a clean record. Immigration officers and judges had some flexibility in determining whether an applicant's overall conduct reflected good moral character. The new law eliminates that flexibility when it comes to DUI convictions. A DUI now creates an automatic, categorical bar to establishing good moral character. It doesn't matter if the conviction was 10 years ago. It doesn't matter if you completed all court-mandated programs, paid your fines, and never had another legal issue. The DUI alone disqualifies you from citizenship. This provision has particularly devastating implications for long-term green card holders who are planning to naturalize. Many immigrants spend years building their lives in America with the understanding that eventually they'll become citizens. That pathway is now closed for anyone with a DUI on their record. And because there's no statute of limitations on this provision, even DUI convictions from decades ago will prevent citizenship applications from being approved. State versus federal classification conflict. One of the most legally complex aspects of this law involves the conflict between state and federal classifications of DUI offenses. In many states, a first-time DUI with no aggravating factors is classified as a misdemeanor. Some states even offer diversion programs that allow offenders to avoid a formal conviction if they complete treatment and probation successfully. This new federal immigration law overrides all of that. It doesn't matter how your state treats the offense. At the federal level, for immigration purposes, any DUI is now treated as a serious violation that triggers severe consequences. This creates a two-tiered system where U.S. citizens and non-citizens face dramatically different outcomes for the same behavior. A U.S. citizen convicted of DUI in most states will pay fines, possibly lose their license temporarily, and might attend alcohol education classes. Their life continues relatively normally. A non-citizen convicted of the exact same offense, under the exact same circumstances, now faces deportation, separation from their family, and permanent exile from the country they call home. This disparity is what makes the law so controversial. Critics argue it violates principles of proportionality and equal treatment under the law. Supporters counter that immigration status has always come with additional responsibilities and that non-citizens don't have the same rights as citizens. Impact on families and communities. The human cost of this legislation cannot be overstated. Across the United States, there are millions of mixed-status families where some members are citizens and others are not. These families are now living in fear. A parent with a green card and a DUI conviction from years ago suddenly faces the possibility of being torn away from their U.S. citizen children. A spouse who made one mistake could be deported, leaving their partner and family behind. Communities with large immigrant populations are already feeling the effects. Immigration attorneys report that their phones have been ringing constantly since news of the law broke. People are panicking, asking whether they're at risk, whether old convictions will be enforced, and what they can do to protect themselves. Businesses that rely on immigrant workers are also concerned. Industries like technology, healthcare, agriculture, and hospitality employ millions of workers on various visa categories. If those workers become deportable over relatively minor offenses, companies could face sudden labor shortages and operational disruptions. Processing time improvements and skilled worker provisions. To be fair and comprehensive, we need to acknowledge that this legislation isn't entirely restrictive. The law includes several provisions designed to improve the immigration system and expand opportunities for certain categories of immigrants. One significant change is the reduction in processing times for employment-based visas. The law mandates that U.S. Citizenship and Immigration Services process H-1B petitions, L-1 transfers, and O-1 applications within 90 days. Premium processing, which currently costs over $2,000, will be eliminated and replaced with a standard expedited timeline at no extra cost. The legislation also expands visa categories for workers in STEM fields, healthcare, and emerging technology sectors. It creates a new pathway for entrepreneurs and startup founders, allowing them to obtain work authorization more quickly if they can demonstrate job creation and investment in the U.S. economy. For students, the law extends the optional practical training period from 12 months to 24 months for all degree levels, not just STEM graduates. This gives international students more time to gain work experience and potentially transition to long-term employment visas. These improvements are meaningful and will benefit hundreds of thousands of immigrants. However, they're being completely overshadowed by the harsh enforcement provisions. Many in the immigrant community feel that these positive changes are being used as political cover for the punitive measures targeting those with criminal records. What happens next? Implementation timeline. Understanding when these changes take effect is critical. Some provisions of the law are effective immediately upon the president's signature, which is expected within the next 72 hours. Other sections have staggered implementation dates to give agencies time to update systems and train personnel. The inadmissibility provisions take effect immediately. That means anyone applying for a visa or attempting to enter the United States after the law is signed can be denied based on DUI convictions. The deportation procedures will be phased in over 90 days, during which ICE will be expanding its enforcement capacity and immigration courts will be adjusting their dockets. The good moral character provisions for citizenship applications apply to all applications filed after the law's effective date. However, there's significant concern about retroactive application. Some legal experts believe that pending citizenship applications could be denied based on old DUI convictions, even if the application was submitted before the law passed. Legal challenges expected. Multiple immigration advocacy organizations have already announced their intention to file lawsuits challenging various aspects of this legislation. They argue that the law violates due process rights, creates arbitrary distinctions between similarly situated individuals, and imposes cruel and unusual punishment. Specifically, legal challenges are likely to focus on three areas. First, the retroactive application of the inadmissibility and deportation provisions to conduct that occurred before the law was passed. Second, the elimination of judicial discretion in removal proceedings, which some argue violates separation of powers. Third, the conflict between state and federal classifications of criminal offenses. These lawsuits could take years to resolve, and in the meantime, the law will be enforced. Immigrants cannot wait for court decisions to protect themselves. They need to take action now.